Defense lawyers of Reddit, what is it like to defend a client who has confessed to you that they're guilty of a violent crime? Do you still genuinely go out of your way to defend them? My criminal law professor said that he preferred guilty clients because he could do his best to ensure a fair procedure, but if he lost he didn't sweat it. He took it a lot harder when he would lose a trial for a client that he thought was innocent. 100% agree with your professor. The emotional impact of losing a trial where you don't think your guy did it is pretty horrific. Everyone deserves a defense. It's less about the defendant and more about making sure the state proves its case and can't railroad any defendants. I feel like if more people understood this, there would be less hatred toward lawyers. I certainly did not think of it in this way. Public defender here. I describe my job as part doctor, part tour guide. Like a doctor, sometimes I can cure you, but sometimes I can just try to make it hurt less. Sometimes I can't do either. Then I'm a tour guide who makes sure that you understand what is happening, why it is happening, and try to give you as much choice in the matter as possible. At the very least, I sit next to you in court so you don't have to face the judge by yourself. Also a PD, and I love this description of the job. It's about holding the state accountable. I don't care if my guy did it. If we let the state lock him up without doing its job properly, that means next week it could be you, or me, or your mom that gets sent up for something we didn't do. The point of a defense lawyer is not to get people off their sentence, but to ensure the right to fair trial is upheld. Defense lawyers in that situation will be looking for leniency in sentencing to make sure the justice process doesn't become vindictive or vengeful. I would have thought leniency would be the worst thing for defense. I'm a defense lawyer. 95% of clients are factually guilty. No, it makes absolutely zero difference to our motivation. It's a huge misunderstanding that the justice system determines guilt and innocence. It doesn't. It determines whether the state has enough evidence to lock a human in a cage against their will. So a client actually being guilty has nothing to do with that question. Moreover, the vast majority, 90+%, even if you're a very aggressive attorney, end in a plea. The issue is usually that your client is guilty of something for which they have sufficient evidence, but the state has overcharged. You find a reasonable balance based on the strength of the state's evidence. A trial is a broken negotiation and typically only happens if one side is being completely unreasonable, is dumb, or has nothing to lose. Edit. Hi all, I don't have time to reply to everyone individually, but let me address the biggest topic of conversation: overcharging. Couple points. Yes, it happens all the time. All the time, especially in lower income communities. Police and prosecutors start from the very highest thing they could possibly charge. Here's what doesn't happen, which has been brought up a lot in the comments. Guy steals a pack of gum. State charges him with murder. We plead to robbery. Bargaining in a legal case isn't like haggling for a car. There's not a high ball and low ball and we land in the middle. That's because the defense is supposed to see the evidence so we know what the reasonable charge would be. It's more like this. Guy steals a pack of gum. State charges robbery, battery, assault, and resisting arrest because they allege a scuffle happened during the theft. I look at it and say, okay, the state's got great evidence of the theft and really weak evidence of the scuffle and medium evidence for resisting arrest. So we'll plead to the theft, frick off with the robbery, battery, and assault, and we haggle over the resisting. If I think maybe they get the robbery, then I advise my client to eat the resisting because it really doesn't add too much and the penalty for robbery is 10 years. If I feel confident that they're fricked on robbery, we hold strong and only plead to theft. So basically, if you have a good attorney, we just bash through the overcharging. Does it move the needle? Yes. Do people cop to charges a bit higher than they should because of the threat of the overcharged crime? Yes. But are people pleading out to absurd things they didn't do because the state is waving bogus murder charges over their heads? Good attorneys don't let that happen. An attorney has an ethical duty to represent their client zealously. That is true whether we know a client is guilty or not. Whether in court or during pre-trial proceedings, we will challenge and evaluate the state's evidence. True whether trying to get a client off all charges, looking to plea, or just figure out a defense strategy. Innocent until proven guilty beyond a reasonable doubt is a heavy burden. It is a higher standard than guilty by clear and convincing evidence and by the preponderance of the evidence. The reason is simple. If the government is going to take a person's liberty or even their life, they had better not be overreaching. The burden is therefore on the prosecution. A defense attorney holds the prosecutor to that. One thing I've noticed is missing from many top comments is discussion of a lawyer's ethical obligations to the bar and to the court. If your client confesses his guilt to you, you cannot elicit false testimony from your client on the stand. You cannot knowingly present false information to the court, and if you become aware of that falsity after the fact, you have an obligation to correct the record. It can get complicated with things like your client testifying. You can choose not to call your client's friend to the stand if you know he will lie, but your client has an absolute right to testify. When you know that your client is guilty but he insists on testifying that he is not, you can have him give narrative testimony in which you, as his lawyer, do not participate. The standard is typically whether or not you know that something isn't true, not whether you strongly suspect it is. The thing about robust legal defense is it serves a bigger purpose than just keeping one guy out of jail. The state has enormous power to deprive people of their rights, freedom, or even lives. The people writ large need assurance that the state can protect them from crime, but also need assurance that the power of the state is not exercised capriciously or arbitrarily. It isn't so much that we need people to try their hardest to set guilty people free. It's that innocent people need to know that someone holds the state's feet to the fire and ensures that it punishes no one it cannot prove to a very high standard actually did the thing he is accused of. We need confidence that we cannot be hauled off in the night and subjected to a kangaroo court for something we didn't do, or our justice system becomes as big a threat as the criminals it is supposed to protect us from. Not a defense lawyer, just a Fed clerk, but I'm in a docket with a heavy criminal docket. First off, you have to remember that most criminal proceedings end in a plea deal, so whether or not the client is guilty doesn't really matter. Your job as a defense lawyer isn't to prove they're innocent in that situation. It's to make sure the plea in an intelligent and informed way, get the appropriate benefit for cooperating, and don't get fricked over by the govt. Same with sentencing disputes. The exact details surrounding what someone did can have major implications for sentencing even if the basic fact that something illegal happened is already established. As for actual trials, as the defense attorneys in this thread have noted, the goal is to ensure that people are adequately represented. The ideal of the US legal system is that an adversarial process is the best way to establish the truth. I am a defense lawyer as well. TLDR. The criminal justice system is so oppressive I don't care, so if a guilty client or two gets off scot-free, on the whole it benefits society. There are two kinds of defense lawyers, the ones that live for getting an innocent client off, and those that live for getting a guilty client off. I am probably the latter kind. At the end of the day, most defense attorneys, especially those in more rural areas, believe the sentencing and fines for most offenses are outrageous, especially for indigent clients, and perpetuate a system of oppression of the disenfranchised. Marijuana possession $600 2 days jail and substance abuse classes. Operating while intoxicated, whether sitting in a car with the engine running because it's cold, or legit drunk driving, easily $2,000 along with license suspension, increased insurance costs and 2 days jail. Often sentences come with 1-2 years of probation, which drags on with 180 days in jail if they don't do well enough. I had a lawyer. I confessed to my grand theft auto to my lawyer, but I was with 4 others who did it. We spoke of plea options, but he wanted to wait and grant continuances to see how the other cases were built. I ended up getting off like a year and a half later. One guy pleaded guilty and got safe house. Another got probation and 2 of us got off completely. I never had to speak in court other than to ask for continuances when he was unable to make it. Then it just got dropped eventually. I was the only one who lawyered up immediately. The guy who got safe house fell for the "we have you on video" with no attorney present. There ended up being no video. If everyone had lawyered up, we probably wouldn't have got any time because we took a car for a joyride that had the keys in it, then ditched it somewhere else. Some fellow college students saw us in the vehicle and some guy stole some other guy's girlfriend, and that guy went to the cops with information since we were blabbermouths and told people we stole it, and that is what got us in questioning. This was like 15 years ago when I was in college. With all the crime dramas around and the internet, it amazes me that people still fall for that bulls. If there's anything I learned from just watching The Wire, it's that you don't ever talk about crimes electronically and you don't talk when you're being interrogated. I'm a forensic social worker, aka I work in prison hospitals for those who are extremely ill. I do have a few clients who I think are innocent despite jury verdict, and sometimes I have to take the stand as an expert witness to describe their mental illness. One person confessed to violating over 20 children, and as an expert witness I had to defend him. Because of my client laws, I couldn't use anything he told me in trial because of the HIPAA law. On the other hand, I have had innocent people on parole where I've gone balls to the wall as their social worker discussing their character and who they are as a person. I've had a lot of people claim they're guilty of crimes, but at the end of the day it's my duty to help them figure out what's going on inside their brains. A privilege all of us should be entitled to. Former cop checking in. Regardless of how many people I put in cuffs, everybody deserves a right to a fair trial. It's innocent until proven guilty, not the other way around. For any defendant, whether that's Cosby, Dahmer, R. Kelly, or the old guy down the street fighting a speeding ticket, my hat's off to the defense for doing all they do. They have my utmost respect because they really do put in 100% to ensure a fair trial. I think it's interesting that you see ethical questions like this for defense attorneys a lot, but not the obverse of that coin for the prosecutors who deliberately send innocent people to prison. That to me seems just mind-blowingly unethical. I guess my sympathies are more with those innocent people because I've seen several lives messed up that way, some of people I care a lot about. The goal of a PD is to ensure that the state can't lock someone away without that person first having their rights defended to the fullest extent of the law, and in doing so they create a legal system where the rights of the accused are protected. I have absolutely no relation to lawyers, but there's a scene in Brooklyn Nine-Nine when Jake and Sophia are arguing about their jobs. Sophia, being a defense attorney, says that it is her job to make Jake prove that the defendant committed the crime. I feel that that is a very LI5 explanation. My father is a lawyer. I asked him once why he didn't do family law anymore. He told me about a case where he was able to get a father full custody of his children, but by the end of the case my father wasn't convinced that his client wasn't molesting the children. If they admit guilt, you have an ethical duty to not make false representations to the court. You have to work your best with the laws, you have to make some sort of defense. You can argue that the law is unconstitutional, that he is insane, etc., but you can't lie and say he is innocent. Frequently, I do not ask outright if someone did it or not. You can sort of tell. For example, you can ask, would you be willing to submit to a polygraph test about that? And if they say no, you can be pretty sure they have something to hide, unless they have another reason to not submit to one. However, most of the time, we are not arguing someone is innocent. We are arguing that the defendant should get a lighter sentence and that there are mitigating factors. There are some people I will never defend, namely child diddlers, because I hate them too much to zealously defend them, which is a conflict of interest, and B, if I did zealously defend them and get them a slap on the wrist, I'd hate myself for it. When I started my first week of medical school, one of the dean came to chat with my class. He related a story regarding his first day in medical school ages before. His class was required to sit at their desk and contemplate something his professor had written on the chalkboard. Primum non nocere, which in Latin means first, to do no harm. This, of course, is part of the Hippocratic Oath. He told us that he felt deeply moved by this concept. Later that day, he ran into a close friend, whom he describes as being despondent and nearly in tears. His friend had started law school that same day, and was also required to contemplate something written on the chalkboard. Apparently, the message written with the practice of law has nothing to do with justice. The law student informed the dean that an attorney's job was to do whatever was required and permitted to protect and defend his client. I still remember that lecture. It left a deep impression in me. No questions, just sharing. So I have a customer who is a defense lawyer, we'll call him Joe, and I had a long talk about this same thing with him a couple of weeks ago. Joe said that he never asks, and borderline avoids his client telling him if they are guilty or not. Knowing puts the lawyer in an ethical conundrum where he cannot put his client on the stand, allowing him to lie. Joe told me that the one time his client told him he was guilty, Joe got himself removed from the case. Absolutely, everyone deserves my most zealous representation. I don't care if you cannibalize your own mother. If the police violated your 4th Amendment rights, you're getting a motion to suppress filed, argued, and hopefully granted. The system falls apart if we abandon due process to reach the right result, even in cases where it's patently obvious what the right result is. If the police feel like courts will make an exception for sloppy work because the case is bad, and believe me, plenty of appellate courts do pull that kind of bulls, then their incentive for doing things the right way goes down. When that happens, society as a whole suffers. Unlike TV, 99% of crimes are not whodunits where police have to choose between multiple suspects. Usually there's no doubt who committed the crime, so my job becomes more about protecting the client's rights and helping them get a better sentence. Better question would be, prosecutors of Reddit, when you know you've put innocent people in prison, do you understand you've ruined their lives? Not a lawyer. My law teacher in high school was a former defense lawyer. She quit lawyering because she defended and won a case where she knew her client was guilty for killing a child. Greatest law teacher ever. Everyone deserves constitutional protections. It doesn't matter what you've done. The Constitution isn't pick or choose. Defense lawyers, at least public defenders in the US, focus on that a lot of the time. Child rapists can be hard, but if you remember that the Constitution still applies, you can get through. It's a certain level of objective detachment. A defense lawyer makes sure the government isn't steamrolling you and is actually following procedure. Defense lawyers are a bulwark against government overreach, or they should be if they're competent. Also, a lot of people who do violent crimes, I believe SCOTUS just held that pickpocketing is a violent crime for sentencing determination, so violent is a legal term that can, very wildly to say the least, have fricked up lives. I know a guy who is severely schizophrenic who thought a woman was an angel robbing him, but it turns out he was mugging her with a gun and didn't realize it. He thought he was getting his money back from a thief. Public defenders, usually, try and focus on hooking people up with services and healing that they may not even know about. Also, there are loads of women specifically in prison for violent crimes who are there because they were defending themselves against their abuser and got sentenced. I personally know a woman who'd been in jail 20 years for killing her abuser who went after her child one night. Cynthia Brown is another great example. These stories aren't the exception. People who commit violent crimes are still people. Not everyone is a raving heartless monster, or Ted Bundy. Those are the exceptions, and even then it's still not the hardest thing to defend if, at least in the US, you frame it not as letting someone guilty get off. Surprise, most people do not just get off. I really hate when TV shows are like he got off on a technicality. Is the 4th Amendment a technicality? Is that really what you're saying right now? I've never really understood the hate for defense lawyers. They are a vital part of the justice system, making sure the prosecutor is doing their dang job properly. You know who are the true bottom feeders of society? Freaking real estate agents. Camel traders and carpet sellers shouldn't have a worse reputation than real estate agents. I make sure I hold the government to their standards at every single level, from the cops to the government janitors to the prosecutors and judge. I don't care if the guy did it. I care if he's getting treated fairly every step of the way and not getting punished too severely. I live by Blackstone's theorem, which makes it hurt more if they didn't do it. My friend who's studying law told me that the defense lawyer's role is not to defend a person per se, but rather to make sure that the trial is led the way it should be, according to law. Not sure if that answers your question, but that helped me understand how do people who are accused of grave crimes find anyone to help them. The state has to prove guilt beyond a reasonable doubt. They have the burden, not the defense. Additionally, an attorney is ethically required to zealously advocate for their client and cannot minimize his or her effort. In some instances, an attorney may tell a client to not tell them what they, the client, did in order to evaluate the strength of the state's case. My girlfriend is a public defender and she always told me that she doesn't have to like her clients, but she has to make sure they have a fair trial. I get this question a lot. First, I usually remind people that my function as lawyer is materially different than judge or jury and does not require me to assess guilt. If I know someone is guilty, it doesn't change my function. Please know that functional does not mean robotic or consciousless. Second, I indicate that a court of justice is not a court of popular opinion or emotional retaliation. As a society, we have found boundaries appropriate for justice in terms of treatment and punishment under the law. Indeed, impartiality is a core concern for our judges and juries. As to the appropriate boundaries for justice mentioned above, we, as a society, have also agreed that all persons shall be treated equally under the law. Third, and aside from the core principles mentioned above, attorneys' licenses are often regulated by state boards. Among the regulations in nearly every state is the duty for an attorney to zealously advocate for their client. It's worth noting that many states also explicitly reference withdrawing from representation if an attorney has a material disagreement with their client that would impede their ability to represent them. Conclusively, we can see that our legal system is designed to benefit all equally and that fairness and impartiality are core concerns on the sides of both adjudication and representation. It is the special role of criminal defense attorneys to honor the principles of law before their own personal motivations. It's a duty above self thing. In honor of evolved and learned society, in fairness and with respect, the existence of your question is why lawyers must be regulated and why laws must be adjudicated by impartial persons. And one final sentiment: many persons charged with gross offenses believe themselves to be monsters or less worthy. Many of them have been victims themselves in transformation to what they have become. And while choice is always available, you might consider the original position model of ethics as to what person would ever choose to be so despised by society and plagued with behaviors of condemnation. Mercy is meaningful and equal treatment is cognizant that truth and reality are contextual to our immediate existence. I hope you found my answer to be beneficial to your understanding. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.